Okay, some breaking news here just out today. This is from South Carolina. In federal court, a federal jury has found that the Richland County Sheriff's Department is liable for civil rights violations after a former deputy repeatedly tased and arrested a 58-year-old woman in her home in 2019. So the $550,000 verdict, but only $50,000 of that was against the officer in the federal claim. I mean, really, what is it with police officers across the country tasing all these elderly people, and in particular, women? I mean, you could just search through the YouTube search function and look at all the instances out there of this happening. I mean, why? Just why? There has to be accountability. And here, I haven't gone through everything, but it appears that there has been some accountability. So what I've done is I've already pulled all the case documents from the federal court proceedings, and I'm going to post them all on the blog. I'll put it in the description. So you'll have everything from the lawsuit itself. I've got deposition transcripts. I've got the actual jury verdict form. I've got the jury instructions. I've got some of the legal rulings on the underlying issues. And I'm going to put it all on the blog for you to review. And why do I think this is important? Why do I want to make this available? Well, these are all public records, but so many people ask me about how do I represent myself? If I can't find a lawyer, civil rights lawyer, how do I represent myself pro se? Well, you need to have documents to go off of. So these are documents you can look at where there was success. I mean, it's not $500 million, of course, but it's $550,000 verdict. And so you can look at the jury instructions that were used in that case. You can look at the legal rulings that were used in the case. You can look at the deposition questions that were asked in that case. And you can take as much time as you want and review it. So let's go through it real quick. And again, I'll put the link in the description. Now, reviewing the exhibits that were used at trial, it's obvious that there was body cam footage from at least 2 police officers that were involved in this incident. I have been unable to find it anywhere, so I have to speculate that it has not been publicly released. But there's no reason why it should not now. So somebody please go right now in Richland County, South Carolina, and try to obtain the public records body cam footage from this case. Now, here's what happened according to the federal court. The parties agree that on the afternoon of February 1st, 2019, the officer was dispatched to an address in South Carolina to respond to a complaint made to 911 by the plaintiff, who was a 58-year-old female. She complained that her brother, William, had unlawfully used their incapacitated mother's vehicle. The police officer, Duecker, Duecker, however you pronounce that, responded to the complaint in his patrol vehicle while wearing his Richland County Sheriff's uniform and the full kit of gear that was issued to him for patrol purposes. Based on the body cam evidence, Duecker, through the front door of the residence, spoke first with Jones, informing her that he had been dispatched about a stolen car or something about a car being used without Mom's permission. To which Jones called inside the house, stating, "Billy, Sheila Dunn called the police and said you stole the car." Duecker then yelled, "Here's the deal," and plaintiff became upset, telling Duecker to back up, that she's a soldier, identifying herself as Colonel Sheila Webb, and stating that the car was not registered, there's no insurance on the car. Duecker responded by taking out his handcuffs and informing plaintiff that the car was legally parked, and if there was an issue with permission to use the car, that was between Gossett and the owner of the car. Duecker then told plaintiff that if she called 911 again, Duecker would take her to jail for unlawful use of 911. Plaintiff then became increasingly antagonistic, retreating into the residence, but then returning to the front door, informing Duecker that he would not be arresting her, that she was going to call Sheriff Leon Lott, culminating in telling Duecker that he was not going to do shit. Plaintiff reappeared, continued to be upset, and then once again retreated into the house. Duecker then entered the residence, stating, "You're going to jail for filing a false police report." Duecker followed the plaintiff into her bedroom, while plaintiff denied she filed a false police report and slowly tried to move away from Duecker. Duecker repeatedly told plaintiff to come here, to not fight him, and to stop resisting, as he caught plaintiff's arm and forced it behind her, attempting to put plaintiff in handcuffs. However, plaintiff twisted away and climbed into her bed, putting the covers over her. Plaintiff and Duker then wrestled on her bed, with Duker standing as plaintiff attempted to keep Duker from rolling over her or putting handcuffs on her. During this time, plaintiff asked Duker to leave her alone, stating that she was sick, while Duker repeatedly informed plaintiff to stop resisting and to not scratch him, finally informing plaintiff that she was under arrest for filing a false police report and assaulting a police officer. Also during this time, Duker used his radio to summon other officers for assistance and was able to place one handcuff, but not two, on the plaintiff. Duker then pulled out his taser and over the next 3 minutes deployed his taser multiple times in both drive stun and probe mode. The latter mode was to plaintiff's chest, while telling the plaintiff to stop resisting and while plaintiff yelled for her brother. Duker then placed plaintiff in the handcuffs with the assistance of one other Richland County deputy who had arrived on the scene following Duker's use of his taser, including Corporal Fairbanks, Duker's supervisor, who states upon arrival, "That is a 70-year-old woman, you tased her, what the fuck, what happened?" According to a report written by Fairbanks, Duker relayed the facts of the fight. "After we all calmed down, we went outside, and Deputy Duker told me he was going to charge her with filing a false police report and assaulting a police officer while resisting arrest. I immediately told him that was not the correct charge due to the civil nature of the call. After talking a few minutes, it was decided by both of us, due to her demeanor and level of intoxication, breach of the peace would be the more appropriate charge." All right, the plaintiff was treated by emergency medical services and transported to the detention center. Plaintiff's charges were favorably dismissed on or about March 6, 2019. Then on February 21st or 22nd of 2019, Officer Duker was fired from his position with Richland County Sheriff's Department. Following a criminal investigation, Lieutenant Eisenhoward for the Richland County Sheriff's Department charged Duker with assault and battery, 3rd degree, as a result of Duker's arrest of plaintiff. Magistrate Judge Searles issued an arrest warrant for Duker on February 22, 2020, and the case against Duker is being prosecuted by Solicitor Byron Gibson. So apparently that is still ongoing. Now there's a story to be told here in the jury verdict itself. I pulled the verdict form, take a look at it. So the verdict amount was $550,000. There were federal Section 1983 claims. Now remember, that has to be filed against the individual police officer, who in this case was fired and thrown under the bus and is being prosecuted. So what does that mean? That means that the plaintiff, trying to gain justice, trying to get compensation, trying to get accountability, is basically SOL if that officer has no money. So in order to get some liability on behalf of the employer and to try to stop them from escaping liability, they filed state tort claims. So you can file a state claim along with a federal civil rights lawsuit, and that's what they did here. And so look at and both of them went to the jury. So look at what the difference was. The individual claim against the officer, the Section 1983 claim, the jury awarded $50,000 against the officer. He was the one who did it, who got fired and is being prosecuted, and also probably has no money. But against the Sheriff's Department, the Richland County Sheriff's Department, they awarded $500,000. So the $550,000 verdict, but only $50,000 of that was against the officer in the federal claim. Then $500,000 of it was the state law claim out of South Carolina. And what does that mean? It means that the state legislatures around the state, they should be enacting legislation that provides some sort of method of accountability on these state law claims, because that is the major problem with the federal claims, is that if they just throw the officer under the bus, the victim can't do anything about it. I mean, yeah, you could get a bazillion-dollar verdict against the police officer, but if he has no money, it doesn't make any difference. It doesn't get you anywhere. So you've had to spend real money, or somebody has, real money prosecuting that case. There has to be liability there at some level on the agency, because the way of doing that now via what's called a Monell claim is not good. You have to show that there's a pattern, a practice. It's very, very difficult to do. There should be some sort of vicarious liability, and you have that with some state statutes. So I think that's the interesting thing here, is it was the state law that actually got the $500,000 for the victim in this case. So as always, thanks for watching. Remember, I'll put all of these documents for your review on the blog post you'll find linked in the description. Remember, freedom is scary. Deal with it. I'll see you next time.